Hello, I'm Maria Ressa. Welcome to Talk Thursday. Today we speak with University of the Philippines law professor, attorney JJ Disini. He's one of the 5 lawyers who argued against the cybercrime law during the oral arguments in the Supreme Court on Tuesday. JJ Disini, welcome. He joins us today to explain why he's against the controversial law. JJ, why are you against this law?
It's actually 4 different things about the law, and libel is sort of the anchor to the argument. And libel, when you tie it to the argument, you link the constitutional right of freedom of expression and freedom of the press. So the first problem is that the increase in penalties from the original penalty to an increased penalty just because a crime has been committed by, through, or with the use of ICT.
Right.
And then Section 7 says that not only is a penalty higher, but you can be prosecuted under the original law as well as the new law. And since the new law only defines the means by which you will commit a crime, we believe that violates double jeopardy. In other words, you're being punished twice for basically the same offense. It's just the means that's different.
Correct.
That and that there's an equal protection issue such that it would seem that users of ICT are being treated differently by Congress, and just because you commit a crime using ICT, the penalty is higher, even though it has not been demonstrated that the effect of the crime is greater. So in fact, in many instances, we can demonstrate that even if the effect is the same or even smaller, just the use of ICT under the law will attract higher penalties.
Yes.
So the second problem would be Section 12. That's the real-time collection of traffic data. That's where essentially the law enforcement agencies are allowed to surveil us by using just traffic data. And traffic data is information about the communication except the content. So cell phone numbers that you dial, incoming cell phone numbers, as well as the same kind of data for your SMS.
Right.
And for all your, say, web surfing activity, they can know what sites you go to, what sites you go to, how long you stay there.
Right.
All of that is traffic data.
Right.
So that's surveillance. And the worst provision is Section 19, and this is the takedown clause.
Yes.
And by takedown clause, what it does is when the DOJ makes a prima facie finding that there's a violation of the law, the DOJ has the right to issue an order to service providers asking them to take down or block access to that content. And we argue that if enough complaints are with the DOJ, at some point it's going to look like the Great Firewall of China.
Right.
And there's no obligation on the part of complainants to even go to court anymore, because if the DOJ has already blocked the item, let's say I'm a victim of libel,
right.
If the item is already out of the consciousness or out of the Philippine internet, then I'm protected. There's no need for me to even seek a conviction. So instead of being required to prove somebody's guilt beyond reasonable doubt,
yes,
I only need to show a prima facie finding, and that's really just at first blush, that's what it means. So it's just a first pass, a first look at the case, and then the DOJ will take action immediately.
That's 3. Increase.
That's 3, yeah. I know, because the 4th will be libel.
The libel.
But libel is the one
that
ties everything in.
Right.
So when you talk about so if you are going to say make an expression, you're going to post something, you're now more scared because of Section 6 and Section 7, because you double your liability and the second liability is greater.
Right.
And then Section 12 may subject you to surveillance as you are doing this. But worst of all, assuming that you even went as far as to actually publish the article, Section 19 allows the victim, so to speak, to go to the DOJ and take that down. Now, for freedom of expression, there's such a thing as prior restraint. That means that even before you make the speech, a particular practice of the state will restrain you, will stop you from making that speech. And we argue that Section 19, to the extent that there's a very low bar to get the order from the DOJ, is an effective prior restraint. So even though you could take the content, put the content out there on the internet, after 1 or 2 days, once the DOJ issues its order, then it's down immediately. So it may not be censorship before, but it's after the fact and immediately, in a very short period afterwards.
Yes. What did you think of the way the oral arguments went at the Supreme Court?
I think the oral arguments went well. I mean, we have to put that into perspective.
Yes.
Only the petitioners presented.
Right.
So we're only just seeing one side of the case. We're not seeing the Solicitor General argue the case in behalf of the respondents. And so it was a chance, more or less, the way I like to think about it, it's a chance for the justices to stress test our arguments. And I think a lot of that went on. at the oral argument. And that's really the difficulty.
Did
about
anything
arguing.
surprise you?
Yes, actually. I was very surprised at in a very insightful interpellation by Justice Leonen of Attorney Cruz involved, and he was citing the different provisions in the Constitution, and in particular, he was citing the privacy of communication, and I think that's Section 2. And in that section, it says that the privacy of communications and correspondences shall be inviolable by the state,
Correct.
except as may be provided by law. And I that phrase, was not aware of that phrase being there. And what he said was that, isn't this that law? If you're making an assertion on privacy rights, basically you're saying that.
Right.
Statutorily, under the Constitution,
Yes.
Congress is authorized to set the standard.
Correct.
And isn't that what Congress did in this case?
Did it make you, I mean, again, that was an interesting point also.
It scared
Because it's already there, right? It's already.
Because I was up next. I was afraid he was going to ask me the same thing.
Yes.
Because I was going to make a privacy assertion on
Yes.
Section 12.
Yes.
And so the only thing I could think of, and so when I stood up actually for the
Yes.
oral arguments, I was very, very nervous because I was trying to figure out what would my response be. And eventually I settled for something like, well, if you're going to allow Congress to set the bar,
Right.
like where privacy is, to the point that they might actually remove the right to privacy, that couldn't have been contemplated by the Constitution, and therefore that provision must be read back to say as provided by law should
Right.
actually mean as be provided by the Constitution. In other words, the Constitution sets the minimum bar, and Congress cannot go below that bar. And certainly, it's the job of the Supreme Court to bring it up
Correct.
to that bar.
You've done a lot of research. You were one of the first people to really look at this law. What was behind the minds of the legislators? Why? What were the concerns that created this law?
That's a very difficult question to answer. What motivates them? I think they were. There was no ill motivation here. I think they saw the problem.
Right.
They spoke to the DOJ.
Could you just say what is the problem?
Okay,
first?
so I think the problem and the reason why there was so much focus on libel, when you talk to law enforcement authorities, so you talk to the NBI and the PNP,
Right.
and what they'll tell you, what they've told me, is that 60 or 70% of their dockets, of their cases that are filed before them, are libel cases. This is somebody, saying something bad about them on Facebook, or somebody.
People can't play nice, basically.
Right.
60 to 70% of cases.
Some comment. So a large part of the problem involves libel.
Right.
And so I think they put that into focus, and they realized that the internet moves so quickly, and that in a sense, they wanted to strike a balance
Yes.
between what law enforcement can do in order to protect sort of the dignity of individuals. And I think in a sense, they felt themselves to be the victims too, because it
Yes.
would not be unfair to say, especially in the case of Senator Soto. He was the victim of this kind of attack from different sectors.
Right.
Unfortunately, as public officials, they really don't have that remedy
Choice.
anyway.
Yes.
But the way the system has worked, even though they're not supposed to be allowed to file libel cases, some of them have actually been successful in pursuing. And actually, that's the case that Harry Roque brought up, which is the case of Adonis, where the allegedly libelous material was one directed at a public official.
Right.
Normally, that would not be. Under the law, actually, that is not actionable. But Adonis did not appeal the decision, I think, beyond the Court of Appeals, where he lost. But if he had gone to the Supreme Court, he would have won. So this guy actually went to jail. Right? And this gave Harry the opportunity to raise constitutional issues, or sorry, international law issues,
Right.
before the UN. And he got a favorable advice, that the law in the Philippines on libel is something which violates the International Convention on Civil and Political Rights.
Right. Well, for ordinary people, so you talked about what the lawmakers may have been thinking. Why should ordinary people care about this?
About
this cybercrime?
I think there are a lot of people who have been victimized. Right now, even if you talk about, so if people are doing some kind of significant online commerce now, it's probably through coupon sites. Yes. And there have been problems that have arisen, and they don't know what to do. Right? I'm sure there are a lot of instances of invasion. Right? Yeah. So you go check your email and you realize it's been compromised.
Yes.
So things of that nature,
Hacking.
Yes. Right? So some of the more or web defacements.
Anonymous Philippines.
Anonymous
which is
Philippines.
Striking at the government websites.
Right,
Yes.
Right. So you need these people need a way to find remedies. And the other thing, actually, I think what drove the Congress to enact the law the way, and especially in the form that it took,
Right.
was the Budapest Convention, and that's the Council of Europe's treaty on cybercrime. And what it has, one of the things that that law has is, or that treaty has, is that it allows for international cooperation between countries for cybercrime investigation and prosecution. So the Philippines was invited to accede. The Philippines is poised to accede and join the convention. And if that happens, then the Philippines will establish a 24/7 point of contact and will have access to a 24/7 point of contact in all of Europe, the United States, China, and Japan. If a cybercrime event happens in the Philippines, if a site is being hacked in the Philippines, and they detect that the source is, say, someone in Germany, they can pick the phone up, contact somebody, or maybe on Twitter, right, or on Skype the guy in Germany and say, we have this problem, please trace it immediately. So it's an international cooperative effort. We will join that, and I think so. In order to join that convention, you're better off writing your cybercrime law that is consistent with the convention. So many of the parts of our cybercrime law are actually identical to the cybercrime treaty. Yes, identical. So I think Section 4, which defines the offenses, a lot of them are verbatim copies.
Really?
Yes. And indeed, even Section 12, actually, on real-time collection of traffic data, that's also in the cybercrime convention, but it's written differently. Instead of saying that you have the right to do it at a very low bar, they said all the treaty requires is an expedited process by which that could be done. And if a warrant is needed, then the treaty does not impose that it be warrantless. So in the case of the Philippines, so we took a model law essentially, and we sort of Philippinized it.
Yes.
And so they tweaked it, and Congress struck its own balance. And actually, the interesting thing is that the balance was struck differently between in Congress and in the Senate. So the versions were different. I guess I've been speaking to members of the lower house more, and according to them, their version had more protections. But you go into BICAM, the Bicameral Conference Committee, and what came out was this. So the choices were made whether would they go with the Senate version and the House version, and a lot of the provisions that are being questioned came from the Senate version, like the provision on libel. Section 19 came from the Senate version. Section 12, without the warrant requirement, was from the Senate version.
The Senate version.
I think even 6 and 7 on the double jeopardy provisions were not in the lower house. So many things were injected from the Senate side.